Ready? Start. The petitioner, a proprietary firm, is engaged in providing marketing and promotion services to its customers located outside India. The overseas customers to whom services are provided by the petitioner are inter alia engaged in the manufacturing and sale of goods. Such customers may or may not have an establishment in India. The petitioner provides services only to its foreign principal and receive consideration in convertible foreign exchange. To provide such services, the petitioner enters into an agreement with its overseas customers. Illustratively, a copy of one such agreement is placed on record at Exhibit C. Under such agreement, the petitioner provides services to enable his foreign principal to get purchasers for its good in India or elsewhere. The petitioner thus undertakes activities of marketing and promotion of goods sold by its overseas customers in India. Para. The service as provided by the petitioner if an Indian purchaser directly places a purchase order on such overseas customers of the petitioner for supply of goods. Such transaction is enabled as a result of the service so provided by the petitioner to his foreign principal. The goods are directly shipped by the petitioner's overseas customer to the Indian purchaser. This is an independent transaction between these two parties, namely the Indian importer and the foreign exporter, which has nothing to do with the petitioner. On arrival of the goods in India, they are cleared by the Indian purchaser directly from the port. In regard to the payment of consideration for such import, such overseas customers raises a sale invoice in the name of the Indian purchaser. The Indian purchaser directly remit the sale proceed to the overseas customer. Thus, the petitioner has no concern whatsoever qua such import transaction. Para. Once such payment is received by the overseas customer from the Indian importer, the foreign principal pays a commission to the petitioner against an invoice issued by the petitioner. The entire payment is received by the petitioner in India in convertible foreign exchange. Para. The petitioner's establishment is registered as a supplier under the provisions of the Central Goods Service Tax Act 2017. It is not in dispute that the petitioner on such transaction has deposited CGST at the rate of 9% and the state GST under the Maharashtra Goods and Services Tax Act 2017 at the rate of 9% under self-assessment. At no point in time there was any independent demand by the authorities for payment of GST either under the IGST Act or the CGST Act. The petitioner has contended that the nature of the transaction entered by the petitioner with its overseas customers are transactions of export of services, as the petitioner was providing services to its overseas client which were consumed and used by the overseas client outside India, for which valuable foreign exchange was earned by the country. Hence, such transactions were outside the purview of the CGST and the MGST Acts. The petitioner therefore addressed a representation dated August 22, 2017 to the Superintendent CGST Mumbai Range 1 inter alia, recording that with the advent of goods and services tax in terms of section 13 in bracket 8 bracket close to the IGST Act, the place of supply of intermediary services has been defined as the place of the supplier of the services. Stop.